Good morning. I'm Sharon Douglas, your host for Things You Need to Know. This morning we have a special guest, Nathan Graham, a construction attorney. Sometimes we need help to understand the language of the contract. Good morning, Nathan.
Good morning, Sharon. Thanks for having me.
Indeed, it's my pleasure. Nathan, we have several questions this morning, and I'll start off with the first question. Contract wording, which is ambiguous or subjective, can be interpreted in different ways. Tell us some of those ways.
Yeah, well, I think you touched on, kind of a big idea here, and that is that contracts try to, in their best form, allocate risk and expectations between the two parties to the contractor, if there's one. And so if there's ambiguity in some of the wording of those expectations or how the risk is allocated, then that can cause problems and disagreements down the road, because it's possible that each side to the agreement has a different understanding of what that ambiguous language means. And for example, whether or not something is in a scope of work or not, who's responsible for cleanup of certain areas of a job site, who's taking risk for environmental factors, or even who's responsible for damage to the work before the owner accepts it. And so there are all these things that could have some ambiguity that you need to be careful about, and that's just a few examples. I mean, there's a long list that you need to be careful about as you're negotiating your construction contracts.
Okay, that being said, sometimes we put together proposals and we have exclusions. Can those exclusions be incorporated into that particular contract?
That's a really good question, and it's something that comes up quite often. And I've seen many times over the years where a subcontractor will put exclusions in their bid and submit that to the general contractor, and those exclusions may or may not make it into the final subcontract. And I've often seen disputes where subcontractors believe that they have excluded something from their scope of work or from what they're responsible for doing based on what they included in their bid, but that didn't necessarily make it into the final subcontract. And then they believe they're not responsible for doing something, whereas the general contractor is quite confident that they are. And that leads to a real big problem. And it also ties into the idea that most of the time, construction contracts have what's called a merger clause at the back that says basically the only agreement is what's on these pages and there's nothing else. And so their subcontractor's reliance on their bid is misplaced and often causes some real trouble.
So what would you suggest to that subcontractor in regards to including those exclusions?
I would suggest that you be diligent about making sure that everything that is important to you about your exclusions and your scope of work actually makes it into this final subcontract document.
Absolutely.
And if you're being told, don't worry about it, we know you have an exclusion, I would still insist that whatever you think is important to your agreement and what you're doing, make it into the final document, and that you insist on that.
Absolutely. My second question, why should we pay attention to boilerplate language in contracts?
That's also a good question. We often use the term boilerplate to talk about really any term in a contract that is kind of long and nobody wants to read and is there just all the time. It's all those things that get tacked onto the back of contracts that most lay people just don't bother reading. The thing to remember is that all of those provisions are there for a reason, and someone included them in the agreement because they thought they were important. Some that often get overlooked from the business side of things are, like I mentioned earlier, the merger clause, which collapses all prior discussions into a single document. Meaning if you've been told something before you were signed the contract, and it says in the contract, I'm not relying on any representations outside of what's in this document, then that's a real problem for you if you believe that there's some other agreement that's outside there. Another one that's very timely right now is how what's called force majeure clauses are worded, which is basically how do you deal with things that come up during a project and during the prosecution of work that are outside of any party's control. You know, escalation of prices on materials is sometimes there, weather, acts of God, all of those kinds of things. You've seen it added recently, the idea of what happens if there's a pandemic work shortage. And the issue with force majeure is who amongst the owner, the general contractor, the subcontractor, the material supplier, who amongst all of those parties bears the risk of their interest not being met if one of those things happens. So if there's a weather delay event, whose pocket does that eventually come out of? If there's, all of those kinds of things. And we sometimes overlook those clauses because we don't really think that they're going to apply to us. They think, that's somebody else's problem. But in reality, they often come up and are important when things don't go as expected.
So what you're saying, in essence, is the trickle-down effect.
Yeah, that's one way to put it. It's think of it more as a kind of a continuum, right? There are all sorts of risks and rewards associated with building a construction project. There are all sorts of things that can go wrong, and there are all sorts of things that can go right or better than expected. And we do our best in the building of things to plan for those contingencies. But there's a question, as you're talking about the legal obligations between all of the different moving pieces that go into building that thing, as to who takes responsibility for different pieces of risk. So if materials escalate in price, whose risk is that, right? Is it the subcontractor's risk? Do they get squeezed because they had a guaranteed price to the general? Is it the general contractor's risk because they have a guaranteed price to the owner, but they couldn't get their subcontractor to agree to a guaranteed price? Or is it on the material supplier who, is trying to get the best price for their materials? And it's kind of a sliding scale, right? You have the opportunity at every stage of that and between each party to allocate that risk and decide who's going to carry that. But it often gets pushed down.
Understood. But I still have another question. When you recognize that you're in this situation as a subcontractor and you said that, for example, we have an issue right now with material costs. Who receives that risk? How is that risk mitigated for the smaller contractor?
So that's obviously a very timely issue. And a lot of people have been talking about what is the best way to allocate that. The simplest answer is that is going to be in your construction contract, and it's going to relate in some ways to the type of construction contract you have. So if you have, we can answer this question at like a 10,000 foot level, and then at 5,000, and then we can go all the way down and get really granular with it. At the really high level, 10,000 foot, you have different contract structures that by their nature allocate risk amongst the owner and the contractor group as to who is accepting risk of material prices. On one end of the spectrum, you have a fixed price lump sum agreement, and in that style of agreement, the contractor group is accepting the risk of price changes, right? On the other hand, on the complete other side, you have a cost plus agreement where the owner is paying the cost of the work plus some sort of fee or markup. In that instance, the owner is taking all the risk on the cost of materials. They're also bargaining for transparency in what those materials cost, and they're taking gambles in a way that if the material prices drop, then they get the benefit of that. So there's a give and take to the whole thing. Then there are also some hybrid situations. You've got, cost plus the guaranteed maximum price. You've got construction manager at risk. You've got all these other things that are mechanisms really for, at a very high level, for who accepts the the risk of what the materials and subcontracts are going to cost. That continues to flow down. Now, even in the context of a fixed price lump sum contract or a fixed price unit price contract, you have the idea of there are circumstances where things happen beyond your control where you should be allowed to adjust your price. That is really a contract by contract thing, and it's an individual negotiation thing. And so there's no one answer as to what the best way to do that is. It's simply something that if that's a concern of yours, you need to be sure to address it with whoever you're contracting with, so that you have that conversation up front and everybody knows who is taking on the risk of material price changes and at what stage and in what circumstances. In the public contract context, you can do that a couple of ways. There are some states, if you're talking about infrastructure contracts, some states, not Texas, but have what's called a price adjustment clause. And so they have set metrics where if there is a significant change in the price of a particular material, then the contractor can go back to the state and ask for a price adjustment. TxDOT's looked at that, but to my knowledge, they haven't implemented it as an example. But there are other things and other, obviously, contracting bodies, and there are other structures. And so really, the answer is it really depends on your individual contract and your individual project and situation, and what the benefits and risks are to each party so that they can negotiate that.
Understood. I'm going to go back and emphasize to our audience that Texas has not changed their procedure or process when it comes to increases. So we know that other states have. Is that correct?
Right. Well, yeah. So, the most current information I could find, and if somebody else finds some other different information, I wouldn't dispute that. But the most current information I could find was that TxDOT had a study done a few years ago about price adjustment clauses, and they determined that several of the surrounding states do have them. If we're talking just about highway projects, so several of the surrounding states do have price adjustment clauses, but TxDOT elected not to implement them because they felt like basically there were too many variables. Now they do have, the TxDOT does have a change order process. So if the scope of work changes, there is obviously a negotiation for what the additional scope of work would cost. And there's also a clause in the TxDOT manuals which will allow you to ask for a price adjustment or a contract adjustment if the quantities vary over a certain percentage in certain contexts.
Right.
But that's not really the same thing as the price of your materials went up and so you need a change. It's more of there has been a change to the work. You've got a quantity increase over 25%. That changes the economics of what you're providing to the state, and therefore they've allowed for some adjustments there. But really, you need to go by the TxDOT contracting manual, and really that's in the highway world, that's your Bible.
Absolutely. So our next question: verbal agreements not included in the contract have no value. Talk to us about that.
Yeah, so that's, I kind of touched on that earlier, and that's this idea that, going back to the boilerplate language question, almost every construction contract I've seen of any, level of sophistication includes, what I mentioned earlier, which is a merger clause, and it also includes language in the change order provisions and everywhere else that says verbal changes, verbal representations, meaning oral representations, things I tell you, cannot be relied upon. Don't change the scope of work. Don't entitle you to more payment. Don't ever rely on them, and they're worthless. And that's what the documents say. Now, realize that causes a challenge because you're out in the field and you're working with somebody and they're like, yeah, can you just do this and I'll make sure you get paid for it. And that's you have to understand that circumstance. That's a risk that you're accepting, that they're going to follow through with what they said they were going to do and pay you, and document it properly. But as a rule, you really need to make sure that any agreements you make with your contracting parties, so if you're a subcontractor, the general, or going down your material supplier, going all general to the owner, that it's all written down so that it's clear what the agreement is that's being amended. Because often what happens is that someone will get a field directive to do something that's going to say, oh yeah, we'll put it in a change order, it'll be fine. And both sides have a different understanding maybe of what that's going to cost, how long it's going to take, what the impact is on schedule, um, all of these variables that both sides have different understandings on, and sometimes that can cause disagreements later.
Right.
So in an ideal world, you would try to get things written down as they happen, but we all understand that construction projects are dynamic environments, and there are circumstances where things are challenging out in the field, and you have to do the best job you can under the circumstances. But that's the general rule.
So I would ask you is, if you were out in the field and someone asked you to do a different job, and you got that information by text message or by email, would that suffice?
It depends on your contract. Most of the time, if the current contracts will allow for changes in writing, you need to be sure that, and so an email is often considered writing, but there's been recent case law on this issue in Texas that email, if it's considered to be a new agreement or to be an agreement or be signing an agreement, there's a lot of complexity with that. And so you need to be sure, if you're relying on email directing you to do something, that it's clear that what that all the terms that you're agreeing to are in there, because it's again, all of these things, it's not that anything we're talking about right now is necessarily fatal to resolving an issue. It's that the less documentation you have, the more room there is for ambiguity, and the more room there is for disagreement.
Yes.
And so that takes more time and effort to resolve. So if you're able to document things on the front the way that the documents and contracts contemplate, then that often saves you from a fight later.
Understood. So true.
Yeah, and just to be clear on that, we want to be careful not to say, well, never do this, and if you don't get it in writing immediately, then you're out of luck and there's no recovery. Those kind of things, those kind of absolutes, we want to be careful about. But what I can say is that the better you document what's going on, and the better records you keep, and the more fastidious you are about keeping your documents in line with what's actually happening, the less likelihood you will have a disagreement later on.
Emphasis on paper trail, right?
Well, because that's that the emphasis on paper trail, it sometimes forces the issue for people to talk about things that they would have a tendency to delay otherwise.
Right. Understood. So, next question, and thank you for being patient with us on these.
Sure.
What other documents are included in part of your contract? Is the flow down provisions?
Yeah.
As one.
Yeah. So this is another one that people often don't pay a lot of attention to, but should. On large construction projects in particular, you have a whole suite of contract documents that start with the owner, the architect, the engineer, all the way down to the general contractor, subcontractor, subs, trades, material suppliers, all of those things. And often, there will be requirements in the prime contract that certain things need to be included at contracts at every level. And then your general contractor will often also include references to incorporate all of the contract documents from the owner as well, and require that to be part of the subcontracting on down. And the reason for that, from the owner and general contractor's perspective, is that they don't want to leave any gaps, that there is an expectation that needs to be met to complete the project that should be within, a certain sub or trades scope of work that isn't as clearly articulated in the subcontract documents as it is in the prime contract plans and specifications and all of those things. And so you really, as a subcontractor, my suggestion would be that you be very aware that most often your subcontract is going to also incorporate most, if not all, of the terms of the prime contract with the owner, and that you can be held to those as well.
In that case, my question to you is it possible for the subcontractor to do a strikeout in different areas of the contract that really impacts them when they get ready to perform?
I mean, it's everything's open to negotiation, and it just really depends on your conversation with the party you're contracting with. And if you say, I really don't want to take on the risk of this thing that's in the prime contract, I feel like that's more your thing, I'd like to strike that, then they may or may not accept it. But if they don't, you've at least had the conversation, and going in before you sign your contract that that's a risk that you're taking on, and you can adjust your pricing accordingly.
Right. So if I were to have a contract per se, I'm looking at this contract and is really holding me to the fire of something that I feel like I'm not really going to get paid for. Let's go back to this one. The contract says 60 days for payment. Am I able to make a change even though the contractor says, no, I'm not?
Can you rephrase that one a little bit?
If I had a contract in front of me that said that I would not get paid for 60 days, in other words, the contractor have in there 60-day payout, am I able to strike that even though the contractor has said, do not make any strikes to this contract?
Well, you can of course always try to negotiate a piece of a contract. Really what they're saying when they tell you no strikes is saying, I'm not willing to negotiate with you on any terms. That may or may not be a truthful statement. You don't know until you test it.
Absolutely. I'm just smiling because I've been there. As far as making those strikes, you go ahead and take it to the test. And I'm suggesting this to my audience.
The thing to remember is that contracts are always, it's a document that's designed to say what you're going to do and what you're not going to do. And so in that way, there's always going to be room for discussion and negotiation most of the time. Now, we all know that, we get contracts on our phone for, you accept terms for a website or for an app or whatever. And those aren't, it's not like I can mark that up and go to Apple and tell them I'm not going to use my phone. I mean, I can. The answer is I don't have to use my phone anymore, but I'm not going to do that.
Right. Okay.
But in the construction contract, it's not like you're clicking on a license agreement. You're going back and forth with somebody that you have a negotiation with, and they want you to do something. They want you to build something. They need something from you, and you need something from them. And so it's natural to have a conversation about the give and take, about what each party is willing to do and what they're not willing to do.
Understood. Our next question. Recent changes to Texas lien laws.
Yeah, so this year, 2021, the Texas legislature did an amendment to Texas lien laws, and that was House Bill 2237. And that changes several things related to kind of the process of providing notice for a lien claim. It also includes, for the first time, or at least first time recently, in the definition of labor, the services of architects and engineers, other design professionals. And so they're able now to explicitly file a claim on or lien on property for work that they've done. And then there's also been some amendments to the notice requirements, how those are processed, what you're supposed to send, not necessarily what you're supposed to send, but how you're able to send it, and the deadlines. For example, if a deadline falls on a Saturday, Sunday, or holiday, the deadline is moved to the next day that's not a Saturday, Sunday, or legal holiday. And there's several things like that in the new House bill. And my recommendation on lien law generally is to always go consult the statute and read through and make sure that you are meeting the timelines outlined in there, and you're doing it, and you're doing everything it describes it to the letter. And that's something that even after 20 years, I still consult the book every time, because I'm not going to take the chance that my memory is not as accurate as it could be. So I would always encourage people to always check the statute and follow it to the letter every time, rather than just thinking you remember it.
Would you restate that location to find that information for us?
Sure. So I'm speaking primarily about Chapter 53 of the Texas Property Code. And then the new House bill that amended Chapter 53 is House Bill 2237. And that was passed on June 15th, and I think it goes into effect on January 1st of 2022.
Thank you very much, Nathan.
Yeah, of course.
All right, the next question. We discussed earlier about the escalations of TxDOT. Is there anything else you can tell us as far as the escalations? Has TxDOT changed at all?
Not to my knowledge. I think we quite honestly, I think we kind of accidentally covered that question in the one earlier. So there's not really any new stuff there on TxDOT projects that I'm aware of. They may be considering it, but I've not seen any action.
Okay. All right. Next question. In the legal arena for the workmanship or product quality issues, seldom go into favor of the subcontractor. Why is that?
I think it's just a function of how often who drafts the contracts, right? So most of the time, when you're signing a subcontract, that's on the form written by the general contractor, or a form that they've used. And so that serves, they've covered their interests in writing that. And that includes making sure that they have ways and tools to ensure that their subcontractors complete the job in a way that is compliant with the owner's requirements. And so that, it's just kind of part of the structure of, again, it goes back to the idea of risk allocation. And so as a general contractor, you're going to want to isolate and identify risks that you've transferred to a subcontractor. So if I ask you to do a particular scope of work, I want to be confident that you're going to be held to whatever standard I'm held to, and make sure that you complete that in a way that the owner will accept.
Great. Next question. What can you do if you aren't getting paid? Do you have a right to stop work if you haven't been paid?
Not always. So it really, this is another one where, unfortunately, the answer is going to be, it depends on what your contract says. It depends on why you haven't been paid. There often contracts will have various clauses and provisions relating to payment. Some issues are payment responsibility for payment to a subcontractor is triggered when the general contractor is paid. So you got those pay if or pay when paid clauses. And there are some restrictions on those in the commercial context, and you can always look those up. But really the concept, the large, it's easier to talk about it in a large context, which is you've got the pay if paid or pay when paid issue. You have the what happens if there's a dispute over the scope issue and the owner's withholding payment for some sort of, or the owner or general contractor is withholding payment for some legitimate dispute, and what happens if there's just non-payment for no reason. So if there's a pay when pay clause, then you have to kind of abide by that, absent some very particular circumstances that would take us longer to explain than are worth it. If there's a legitimate dispute, most construction contracts will say that you have to keep working while we sort out the dispute. You can't stop work. That's obviously something that a subcontractor can try to negotiate, but those clauses are often there. And so it's good to be aware of, and this gets back to the boilerplate issue, it's good to be aware of what's in your agreement, because there are often clauses that will say you need to keep working even if we have a disagreement over payment. Now, the slightly different scenario is if there's payment due and owing, there's no dispute as to it, and you're not paid, then at some point that becomes, if you've got an argument that's a breach of the agreement, then that changes the calculus a little bit. But if it's just slow pay because of the owner and you've got a pay when paid clause, or there's slow pay because of a dispute, often the construction contracts will allocate that risk to one party or the other and allow the general contractor or owner to withhold payment. But that gets back to, you really need to read your agreement and understand what you're signing on for.
Right. Now, looking at that from a different perspective as far as the payments go, does TxDOT have a system in place that guarantees the payment to contractors, small contractors?
Well, yes, to the extent that it's due, right? So there is a you can't file a lien on public property, so there's a payment bond that is placed on almost every public project. There are some exceptions for large-scale projects. Occasionally can do that by letter of credit, but if called, it's a payment performance bond that allows the subcontractors and suppliers a guaranteed source of something to file a claim against. Now, the general contractor can, of course, dispute that claim if they feel like, the subcontractor didn't comply with the agreement, or there was something wrong with the materials or work provided, and they can fight that claim. But the idea is there's a source for payment of funds that are due and owing and undisputed.
Okay, and what about, is there a 30-day set payment date for the TxDOT projects?
So the TxDOT projects have, they've got a measurement and payment provision in the construction manual that governs when payments are sent out and how they're processed, and that changes. And so I would just consult the TxDOT manual on that to make sure that where your particular situation fits into the kind of overall scheme that they have.
Sounds good. Thank you so much. And moving on to the next question. When we're looking at our contracts, and we've already signed our contracts and we're involved, what would you suggest to the contractor, a small contractor, when they find I would say, heavy discrepancy in the contract, and that is wording as far as detail of work? I always talk about this word theoretical and how that really gets a small contractor trapped. What would be your suggestion?
I think it goes back to the issue of bringing up issues with the contracting parties. And if you've found what you believe is an ambiguity in your agreement, I would get out in front of it before it becomes something that is problematic. It's a lot easier to resolve an ambiguity and make an amendment to your contract before whatever that issue is pops up and costs somebody money. So if it's still kind of out in the future and you're concerned about the word theoretical in terms of like theoretical quantities or something else, which is based on design documents and these other things, you can go and say, I have a concern with this. It's not really an issue right now, but I don't want it to be later. Can we talk about what this means and how it's going to allocate risk between us?
Okay. Now, as I think about our total conversation, I'm thinking about the overall contract. And can you summarize what you would say to a small contractor that has not signed their contract? So what would you give that contractor as heads up?
I would obviously suggest that they take the time to read the whole thing and
Yes.
understand what they're signing on for. But beyond that, pay really close attention to how your scope of work is defined, what your quality standards are, and who makes the determination on that. Is it, is there a subjective factor or is there some objective determination of quality? The time requirements of when you're supposed to work and what you're supposed to do and when you're supposed to deliver your portion of the work, and what are the circumstances where you can get an extension of time to complete, and whether or not you can get compensated for delay events and what those might be. So when things happen on the job, whether or not that's something you can get extra compensation for. The termination provisions, so what needs to happen if you're going to get terminated, whether or not there's a termination for convenience clause. All of these things that you want to read through, because ideally the contract is going to outline the relationship of the two parties, and it's going to try to cover as many different scenarios as the drafter can think of that might come up in a construction project that they need to account for.
Okay. Nathan, thank you so much.
You're very welcome.
I hope our audience have learned a lot from this. I sure have.
I always enjoy talking to you, so thank you.
Well, my pleasure indeed. I'm Sharon Douglas, your host for Things You Need to Know. Today, we had Nathan Graham identifying different things in the contract language. I hope you've gotten something from this, and remember, this particular project will always be there for your reminder. You can always go back to any of the episodes that we put out here. Thanks again for being with us.